Let me remind Appellate's counsel to let us know when you start your argument if you want to reserve any time for rebuttal. I do want to just take a moment here and acknowledge this is Justice Lee's last time to sit with us, Justice Sharon Lee. She's been an appellate judge for 19 years. 15 of those are here with the Tennessee Supreme Court. And her daughter, Sarah Sharmley is here, along with her granddaughters, Julia and Grace. Can I at least have the granddaughters stand up a little bit so we can see you better? Welcome to both of you. We're so glad you're here. And Justice Lee, thank you for your service.
Thank you. I do want to note one thing. I think our appellate court clerk has left me a handful of chocolate kisses as for a farewell gift. Is that right? Thank you. That's a very special send-off. I appreciate it.
And I will note that no one else up here has any chocolate kisses.
I was just checking that out. I'm like, I'm the only one with the kisses. Thank you, Jim.
Thank you all for being here this afternoon. Mr. Hivner, you may call our first case.
Peggy Mathis et al. Versus 99 Hermitage, LLC.
Good afternoon, Your Honors. My name is Matt Peach of the Nashville Bar, and I'd ask for 7 minutes of rebuttal. May it please the Court, I'm here on behalf of the appellant, which is 99 Hermitage in this case. And what we have today is a property case. And a property case typically comes with a complicated record, complex history, and case law that often goes back more than 100 years. However, my argument today on the two issues presented is that those issues in and of themselves are not incredibly complex or complicated. The argument is nonetheless very important as it relates to a clarification of the elements of adverse possession under Tennessee law. Turning to the first argument, or the first issue dealing with adverse possession, the question bears upon specifically who is the true owner of the property at issue during the time period in question.
Well, don't we know who the owner is based on the deed that was executed?
Well, my argument is absolutely we do. There's no dispute, I don't believe, between the parties that the true owner of the property as of 1990, and I'll just refer to the owner as Eads because through the progression that changes. But there is no argument or no dispute, I believe, that as of 1990, my client, who is purchased from at a sheriff's sale via a judgment lien that attached to property that was held in the name of Whiteacre, there's no dispute that Whiteacre, as of 1990, divested all of his interest in the property to Eads via the installment deed. So the issue, and this is why I call it...
Is that installment deed a combination note and deed, kind of like a land contract I used to see when I practiced law?
Right. The way this one was written basically created a trustee that held the property, held the legal title to the property during the period until the installment payments were completed.
Which was in 1990, is that right?
That's when the payments were completed, right. Correct. And so in 1990, the legal title holder, both legal and equitable, of the property was Eads. The issue, and the only reason that we're here today, is because at no time between 1990 and 2016 was that deed ever recorded. As such, the argument that the appellees are asserting, or that Eads is asserting, is that somehow to avoid the judgment lien that attached to this property in 2009, that somehow Tennessee law allows him to disclaim that deed and his ownership via that deed, and instead substitute ownership through adverse possession.
Well, don't our precedents say as much?
Well,
How do you get around, I mean, there's City National, there's more. I know you make some attempt to distinguish those, but find it a little difficult to do that.
Well, I think the issue for this court is, as it relates to Moore and City of Knoxville, those certainly, there's a reading of those that could say that under that particular circumstance, for some reason, the deed could be deemed irrelevant or disclaimed or not relevant to the purpose of determining whether or not adverse possession applied. I don't believe that case, at the very least, was well-reasoned, in the sense that there is no reference to that, in that case, of the elements of adverse possession or any analysis of who the true owner that was the property was being held adversely to.
Did those cases discuss the predecessor to Tennessee Code annotated 6626-101, which is, the statute that says that a deed is effective as between the parties, even if it's not recorded?
There was nothing in how that ruling was written that made any distinction or effort to distinguish the relationship between the party in possession and the grantor of the deed. And that's why I think that the opportunity that this case creates for this court is to clarify that in Tennessee, that the true owner of the property is an integral part of determining whether or not adverse possession exists.
Does
Go ahead.
Milledgeville United Methodist Church versus Melton help your position or hurt it?
It helps it because Milledgeville makes clear that, number one, the party, the possessor, must hold possession of that property adverse to the true owner. And if the party holding possession is the true owner, you can't hold adversely to your own interest. And that is the
Do you
rule
think there's
that,
any circumstance where you could, for example, if you bought the property, you lost the deed, and you couldn't record it, you lost it, yet you had possessed it openly, all the requirements of adverse possession, would you be able to establish title
I
at
think,
that point to take it out of the former owner's hands?
I think the reason that making the true owner analysis is fundamental to determining the existence or the potential applicability of adverse possession is because that same phrase, that same term, true owner, is exactly what a quiet title action is to determine.
But how does that square with the overall, looking at it big picture? What you're saying is that a pure squatter, somebody who just had no relation to the property but just lived there, just chose to live there with no color of title, no nothing, would be in a better position than Mr. Eads. I mean, the whole goal of adverse possession, the doctrine of adverse possession, is that if somebody is claiming an ownership interest in property, they need to keep their eye on it. They need to know who's there. If I inherit from my Aunt B some property in Arkansas and I don't pay any attention to it for 20 years, the doctrine of adverse possession, you're talking about adverse to their own deed. The doctrine of adverse possession just basically supersedes all of the messiness that can take place in ownership rights, where you have somebody inherited it, another person quitclaimed it, another person loaned based on it. Adverse possession supersedes all of that and says if those people who have an ownership interest don't timely get their eyes on the property and see who is actually occupying it to the exclusion of other people, they lose their rights. So how does your argument square with that overall purpose behind the doctrine?
Well, I think it squares because, number one, I think all parties are in agreement that adverse possession determinations held at that clear and convincing standard are very fact-dependent. And I think that in this case, it squares because if there is no public policy served in terms of trying to get the quote-unquote true owner to pay attention to their property,
But you are claiming through Mr. Whitaker, right? Or are you claiming through Mr. Whitaker?
we are claiming pursuant to a judgment lien.
Right.
That attached
that was asserted against
against
his
Mr.
estate,
Whitaker.
if I remember correctly. So that's
Correct.
that's the origin of the interest that you are asserting. Mr. Eads clearly adverse to Mr. Whitaker, and Mr. Whitaker basically acknowledged, oh yeah, you own the property. So why isn't that the end of the inquiry?
Because at the time that the claimed adverse possession starts, under the facts of this case, Mr. Whitaker, it's impossible to hold it adversely to him because he was not the legal title holder at the time that the installment deed was transferred.
How does it work against Mr. Eads that Mr. Whitaker acknowledged that Mr. Eads? I mean, that creates a loop in my head that I can't reconcile.
Well, I think and when you look at the trial court's original decision on this, there was some reliance upon the fact, well, if you look at the relationship between Eads and Whitaker in terms of Eads' possession thereof, starting before the installment deed or purchase agreement was ever signed, that they were a tenant, then for a period of time they had equitable title pursuant to the installment deed, and then later, after that was paid off, obtained full title. That at no point, if you set aside the analysis of at what point does Eads become the true owner and just look at the relationship, at no point could you call Eads' possession beginning with anything less than permissive use.
He wasn't renting. Mr. Eads wasn't renting. He purchased it. That's adverse to anybody else who would assert an ownership interest, including Mr. Whitaker.
But it has to be, and this is kind of the thrust of our argument, is that for purposes of applying in a consistent way the elements of adverse possession in terms of determining when that adversity period starts, there has to be an adversity to the true owner. Because otherwise, the rest of the considerations in terms of public policy, wanting to get people to pay attention to their property, but also the reason you have open and notorious, to put the true owner on notice that unless you do something, this property is subject to being vested in somebody else.
Suppose that at some point during this time period, Mr. Eads decides to vacate the premises. So Mr. Eads moves out and a squatter moves in. Against whom would that squatter be asserting some sort of adverse possession? I mean, what I find odd is that we kind of have this situation where, given the language of 6626-101, we have, as between, is it Whitaker or Whitaker? I was really hoping it was Whitaker.
I think it's Whitaker.
It's Whitaker, excellent,
You would
okay.
know better than us, so you.
I can't claim any personal relationship, but
So as between Mr. Whitaker and Mr. Eads, we have one situation, right, where the deed is effective as between the two of them because they are the parties to the deed.
Right.
But because the deed was not recorded, we have perhaps a different situation with respect to the rest of the world. So would a squatter be able to adversely possess the property against Mr. Whitaker if the deed is unrecorded?
I think if the deed is unrecorded, a subsequent squatter that takes over the possession of the property after Eads would have to, I think the same analysis has to be applied as it relates to whether that possession was adverse to the true owner.
So who is the true owner in
The
that
true owner
situation?
in that situation would be Eads.
But the deed is not effective. I mean, if the deed is not recorded, it is not effective with respect to anyone else who didn't have notice of that deed.
Well, and so I think the issue, though, is when you have a squatter who's not claiming any title interest, not claiming a conveyance from somebody else, then the common law adverse possession elements and analysis still apply, so that anyone who doesn't record the deed, and this is I think gets into the other parts of this case as it relates to the public policy justification for encouraging and promoting registration, and the peril any owner runs when they don't record a deed against creditors or against bona fide purchasers. I think that the same analysis has to apply, though, as it relates to against whom the possessory interest is held. I don't believe that a functional system could work in which the legal title owner or the true owner is somehow transitory or somehow based upon what perspective you're looking at.
But isn't that kind of what you're saying in some ways? Because your position is also that Mr. Whiteacre, even though he was no longer the true owner of the property, could encumber that property.
Well, it's not that Mr. Whiteacre could encumber that property. It's that pursuant to our statutory scheme, creditors are able to attach liens to property based upon the record owner. But the record owner doesn't make you the true owner. It doesn't give you legal title, and it doesn't give, in a quiet title action, would not have given Mr. Whiteacre at any point during this period the ability to obtain an interest in the property.
I'm sorry, go ahead.
No, please.
How does the fact that Mr. Eads kept on paying the property taxes, even though they were billed to Mr. Whiteacre through all this period, affect our analysis? It was very important to the trial court.
It was. I think it affects the analysis in the sense that as it relates to my position is it as it relates to the open and notorious nature of the possession. Because if you are paying property taxes that each year you are receiving that are in the name of the record owner, and you are not making any effort to correct that, you're not making any effort to let anyone know, let alone officially recording the deed, that that information is incorrect, then that, I think, from a clear and convincing standpoint, is additional grounds for a finding that adverse possession.
But that's
is not
exactly what a
established.
squatter would do, who chose to take possession of the property. I mean, the fact that he was paying the taxes also indicates a claim of ownership. He doesn't want to lose it to a tax sale. He wants to own it.
Right.
So how does that square?
Well, I think, again, this is a reason why in adverse possession cases, it's not a one-size-fits-all as it relates to the underlying facts. And in this particular case, as in contrast to or comparison to boundary disputes or cases where, you may be paying property taxes, but there are other elements of your claim to the property. When you're dealing, in this case, with a commercial piece of property in a commercial building that has had and continues to have tenants over a period of time, the existence of any particular individual in the building really has no practical relationship to a claim of ownership to the building. Because,
Come on.
well,
If Mr. Eads is the one who's renting it out, how is that accurate?
well, just because my point is from what kind of clear and convincing evidence the elements of adverse possession require, that you have varying levels of what could constitute open and notorious.
Well, I mean, if Mr. Whiteacre had looked, he would have seen that he was not the owner. If your client had looked sooner, your client would have seen, oh, this is occupied. Who's occupying it? So, I mean, how does that?
I don't believe from a judgment creditor standpoint that the fact that a commercial building has a tenant means that one person or another is the owner. And I think that as it relates to Mr. Whitaker, I just go back to the point, Mr. Whitaker had no interest in the property after 1990. And it's just more reason why that an analysis of adversity to him from 1990 to 2011 is a legal fiction, because he wasn't the true owner. He wasn't any kind of owner other than on record.
Well, I want to get back for a second to Chief Justice Page's question about payment of the property taxes. Does it really have any impact in this case? Isn't the true issue here whether someone who has not recorded a deed but is the true owner of the property can make and establish an adverse possession claim? So if that's the real issue,
Right.
How does paying the taxes even impact this case one way or the other?
It doesn't impact that issue. The issue that I believe is dispositive, which is what you just stated, because paying the property taxes does not impact whether or not Eads was the legal title holder or true owner of the property, because that fact was established in 1990. And even if he hadn't paid the property taxes, he still would have been the legal title holder.
Right, I mean, if you don't go down the adverse possession road, payment of taxes is not at all relevant.
Correct.
Is that correct? And
Correct.
do you think Mr. Whitaker could have borrowed money, knowing that Mr. Eads did not record that deed? What would have prevented him from borrowing money on this property? And say someone loaning money, taking a lien, recording it, it would all look fine according to the Register of Deeds office. It would be misconduct on Mr. Whitaker, but would your lien still attach to this property that Mr. Eads is the true owner of, although not record owner? I mean, the creditor who loans the money would not know that Mr. Whitaker does not own it.
Well, I think that obviously as it relates to any subsequent action by Eads, so obviously what we have is a judgment lien
Against Whitaker.
against Whitaker. And so the only reason it attached to the property is because it was properly recorded in the county and attached to all property of record that Mr. Whitaker was listed as the owner of. And again, there's clearly there's always going to be an inequitable result.
Well, that's a harsh result for
Right.
Mr. Eads.
Right, and there's always going to be that when you have the statutes that allow judgment liens to attach. And it's the peril and risk that any property owner runs if they don't take the simple step of recording the deed. And I don't deny the lens of harshness, but from a rule of law codification and clarification standpoint of how these two sets of principles operate, I think we've cited in the briefs, there's obviously language from several cases that talk about these things happen, but the courts are not going to intervene to do which one could have easily done for themselves and record the deed.
I mean, it's sort of, is it your position that it sort of comes down to who it makes sense to have bear the risk in these situations? I mean, it would have been really easy for Mr. Eads to just record the deed, right? Whereas, a creditor or a subsequent purchaser, I mean, has to be able to rely on record ownership.
Right, and that's why the perceived harshness can't be dispositive.
Is there anything in this record that tells us why he didn't record the deed other than he just forgot it?
There isn't. There's evidence in the record, that shows that this was not an inexperienced individual. This was someone who had multiple property transactions And so it's not a didn't know kind of situation, but there's nothing that affirmatively explains I mean, one could speculate in terms of maybe there could be reasons why he didn't want to record the deed for some period of time and then forgot after that.
Okay, all right, thank you.
But it's not in the record. Thank you very much.
Good afternoon. May it please the court, my name is Jimmy Bradshaw. I represent the Eads estate. For the sake of ease, I'm probably going to refer to my client as Mr. Eads or Ora Eads throughout the argument, but of course I'm encompassing the whole estate. I also want to introduce my co-counsel Frank Reeves and Ann Langley and my paralegal Pam Gamble, all of whom have been instrumental in helping us prosecute this case since 2017. Also, I've always referred to Mr. Whiteacre as Mr. Whitaker. So if I slip up during the case and refer
I'm
to
not
him
alone then.
as Mr. Whitaker, please understand that I am referring to
I think we know who you mean.
to Mr. Whiteacre. Yeah, Whiteacre actually would be a more appropriate name for a
Agreed.
property
Exactly.
case.
It's a perfect name.
Yes,
for property.
it is.
We use Blackacre in law school for property cases, Whiteacre now.
There's a Mr. Duplex in this scenario, too.
So I guess I want to start out by, we're obviously here to respectfully ask the court to affirm the Court of Appeals decision in this case. There is a complex, complicated 30-plus, almost 40-year history in this case, but the appellants have thankfully sort of distilled their arguments down to 2 points. The true owner argument that we've spent some time talking about today, and also the argument that the judgment lien attached to the property 99 Hermitage and would still be there today and is therefore enforceable, even though Mr. Eads' possessory rights, property rights, title rights ripened into unassailable title on February 7th, 2011. So it's our position on that issue that as of February 7th, 2011, the running of the 20-year prescriptive period, that Mr. Eads obtained unassailable title to the property, free and clear of the recorded judgment lien that was recorded back in 2009. I'll circle back to that, but I wanted to address the appellant's true owner argument and respond to some of the comments of the court during my adversary's argument. So the true owner construct, as I sort of look at it, that the appellants have put on this case is in fact a relative term. So when you're talking about the true owner with respect to Mr. Whitaker, Mr. Whiteacre, Mr. Eads is the true owner. There's no question. Mr. Whiteacre gave him an installment deed. Mr. Eads paid it off. Mr. Whiteacre gave him the installment deed on December 28th, 1990, and the property, at least with respect to Mr. Whiteacre, belonged to Mr. Eads at that point going forward. Now, Mr. Eads, of course, did not record the property, and Justice Campbell was right, it would have been a relatively easy thing to do. I do think there's testimony in the record from Mr. Eads, don't hold me to this, but I believe there's testimony in Mr. Eads' deposition, which was part of the proof in this case, that he, in fact, did simply forget to record the deed. He just forgot. He was an experienced property owner. He had several properties. Knowing Ora and the way he conducted business, it's understandable, for at least from my standpoint, from a personal standpoint, that he in fact forgot. But regardless, it is accepted fact that he did not record the deed, and it would have been
Until much later. I mean, he eventually
until much
recorded
later, until a lot of this arose.
And just as a point of clarity, you're no longer, I know there was at some point a claim based on the later recorded deed, if I'm remembering correctly, maybe in the trial court, but you're no longer relying at all on.
Our argument is that his property rights, his title to the property, ripened and vested on February 7th, 2011 as the result of 20-year prescriptive period under common law statute of limitations. Now, that is the sum of the argument. Now, he did have a deed, and with respect to Mr. Whitaker, he was the true owner. And Mr. Whitaker would have been, I believe, barred from asserting a claim against the property by virtue of that deed, whether it was recorded or not, right? Because Whitaker transferred, conveyed, sold the property to Mr. Eads, and that deed is evidence of that, whether he records it or not. There's no requirement, there's no law in Tennessee that mandates that you record.
But there is public policy.
But there is
in
public
Tennessee
policy.
that's strongly in favor of a recordation system.
100%.
That's how you protect yourself from
Exactly.
judgment credit.
Failure to record, you do so at your own peril. And Mr. Eads,
Even by mistake.
That's why we're in this lawsuit today.
I understand.
So
It's creative
but
work.
That gets to my argument about the nature of the true owner is the contextual situation. It's the context of what you're talking about. With respect to Mr. Whitaker, Mr. Eads is the true owner. With respect to the rest of the world, Mr. Whitaker is the true owner.
But is that really true? I mean, if Mr. Whitaker did try to convey the property, again, that would be a fraudulent transfer
It
of
would be
the
a fraudulent
property. So
transfer,
he's not
but-
really the true owner.
Well, but he is the true owner in terms of Tennessee's statutorily created recording system.
But you just said that's not mandated.
It's not mandated, but failure to do so means you could lose your property rights. So with respect to the way Tennessee operates and the way most recording statutes operate is, if you want to know who the owner of a property is, you go to the Register of Deeds office and look it up and see who owns the property. So with respect to the rest of the world, with respect to anyone who was not a party to that deed and had no knowledge of it, the installment deed, Mr. Whitaker is the true owner. Because
Or at least the rest of the world can rely on the fiction that he is the true
Right.
owner. But he's not really.
Exactly. But that's where the concept of adverse possession comes in, right? Because while the appellant wants to argue that you can't really adversely possess against your own interest, and the concept of adverse possession is not available to someone who doesn't record an instrument, a deed, conveying the property to them, you still have to have the ability to do that. For example, Justice Lee said the concept of a lost deed, right? Let's say, actually one of the true miracles of this case is that Mr. Eads was able to find that deed 20 years later and actually get it recorded. But let's say he actually lost the deed. So he's been in possession of the property for over 20 years at this point, by February 7th, 2011, and he didn't have the deed to record. How is he going to prove his ownership?
He would probably file suit for declaratory judgment to establish a lost deed.
or to clear
Quiet
title.
Quiet title of the.
Quiet title, exactly.
Yeah.
But he's got a 20-year history at this point, and when he actually found the deed and recorded it, a more than 20-year history of exercising dominion of the property, leasing it out, using it himself, leasing it to others.
Which is what property owners do.
Which is what property owners do. Maintaining it, paying the tax bills. And this is where I'm saying, paying the tax bills is, when you're talking about adverse possession, it is important. But I do think that adverse possession applies in this case. The Court of Appeals found what they called the theoretical viability of adverse possession in this situation is not theoretical. It absolutely applies in this case. According to Tennessee case law, longstanding Tennessee case law, going back to City of Knoxville, National City Bank, Moore v. Denning, and even beyond before that. There was a 1909 case I think we cited as well.
So you get around the Milledgeville case by saying it's dictum? Is that your argument?
Well, that's part of our argument, yeah. Certainly it's not, we don't think it's factually opposite. It is distinguishable somewhat.
But the church did win the case.
Church did win the case on other grounds,
Right.
and those grounds formed the basis of the court's ruling in Milledgeville, which was this, that Mr. Melton, who was the defendant in that case, and asserting the claim that he had superior claim because he bought the property from the bank, who, I guess forgot they sold it or there was some mix-up. But Mr. Melton claimed he had the superior right, and the court ruled against him on the grounds that the court found in that case that Mr. Melton had knowledge of the existence of the church's prior claim. Therefore, he was barred from claiming a superior right. That was a creature of statute. But, in Tennessee, we also have a statute that says 6626-103, the instrument not registered or not submitted for recording is void as to judgment creditors. So again, this is where adverse possession comes in, at least with respect to judgment creditors, or quite frankly, anyone purporting to take through Mr. Whitaker, right? So that's where adverse possession comes in. That's where adverse possession is a viable theory, a viable defense, and a viable way to acquire title for someone who has, for whatever reason, not or failed to record his deed.
I'm having a little bit of trouble understanding how you get from, I guess you are conceding that as between Eads and Mr. Whiteacre, Mr. Eads is the true owner, and to Mr. Eads being able to establish adverse possession. I mean, adverse possession takes two, right? So he has to be adversely possessing against someone.
Against anyone claiming through Mr. Whitaker. Now, Whiteacre is not the one that's asserting an interest in this property. It's a judgment creditor.
So
right?
it just depends on who is trying to dispossess the adverse
Right,
possessor of the property.
You can't, I don't think, first of all, I don't think Tennessee law supports the appellant's argument that a holder of an unregistered deed is barred from asserting adverse possession, right? Because it's not just Mr. Whitaker himself who would be asserting potentially a claim, but it would be anybody taken through him. Let's say he passed away and his heirs believe they still own this property, and we're now going to assert a claim. They'd be taken through him, but Mr. Eads would have the right to hold them, and maybe the heirs is not a good situation because I think they would be bound by the deed, but in any event, there are different situations, not just the judgment creditor, but a mortgagor, somebody.
What about a bona fide purchaser? What if Whiteacre just sold it to Joe Blow?
Bona fide purchaser for value who didn't have
Knowledge.
notice of the deed. It would depend on when the bona fide purchaser bought the property. If the bona fide purchaser for value bought the property after the running of the 20-year prescriptive period, bona fide purchaser for value be out of luck. Because the rights that Mr. Eads acquired on February 7th, 2011 exist and arose independently of the deed he got from Mr. Whitaker. The deed, with respect to judgment creditors, et cetera, is void. The statutes say that, right? But his rights that arose after the 20-year prescriptive period that gave him unassailable title to that property arose independent of the deed and cut off any other potential claims. So if
How do you reconcile that position with the statutory provisions that talk about the effect of orders affecting an interest in property? So 25.5.101C and 66.24.119. Can you just, as a textual matter, explain to me how your position is consistent with those statutes?
So those statutes talk about the type or scope of instruments that can be recorded to evidence an interest in property. They don't in any way overturn or obviate the long-standing case law on adverse possession. They just say if you record these, then you have an interest in property that would attach to any property owned by the judgment debtor in that county. Now,
or later acquired. I mean, you're sort of overlooking that later acquired language.
Or later acquired, with the exception of this.
I don't see an exception in the statute.
Tennessee law requires something more than just the mere recording of the judgment lien or the mortgage or whatever instrument you're prevailing under. It requires something more than the mere recording, because the mere recording of the lien itself does not work to dispossess the adverse possessor of their possession of the property. Now, what the statute says is, however, if an action is commenced and effectually prosecuted after the lien is recorded, that action, that, affirmative action, an action is commenced and effectually prosecuted, that works to
But you're-
interrupt or suspend the adverse possession.
But you're saying that if that action does not occur until after the adverse possession rights have already accrued, so after that, either the statutory or common law period, that it's no good.
Which, in this case, is what happened, right?
So
But
you're
where
s-
do you, where is
No,
that? So,
okay,
go
no, go
ahead.
ahead, it's all right. I was just gonna say, so are you basically saying that recording of the judgment lien creates no interest whatsoever
No.
in that property?
No.
But isn't that the impact of what you're saying?
The impact, had SPCP, the judgment creditor in this case, at least initially, the one that acquired a judgment in 2009 and recorded it in Davidson County in 2009, then they sat on that judgment for 7 years. They didn't do anything. During that 7-year period, Mr. Eads' adverse possession rights ripened into full and unassailable title. Had SPCP filed an action against Mr. Whitaker in 2009 or 2010, really until February 7, 2011, it would have been a different story.
But that's enforcement of
That's
the
an
property right.
Exactly. That's an action to enforce, and that
But there's still an
action-
interest in the property once that judgment lien's recorded.
until his adverse possession rights ripen into unassailable
And you're
title.
getting that from Mabry? Is that the authority that you're relying on?
I believe so, but I think it's consistent with City of Knoxville. I think it's consistent with Moore v. Denning. It's consistent in that the rights arise and ripen and become full title when you complete the 20-year the 20-year prescriptive period. So
Well, but if someone else, I mean, if, let's say there was just a transfer of the deed and it wasn't, that ownership changed via adverse possession, I mean, that certainly would be a later acquired property right. I mean, is what you're saying that even if it was a more traditional sort of transfer of property rights, that you would still have to enforce? In other words, that lien would no longer run with that property unless it was enforced? I mean, that can't be what you're saying.
no, but what I'm saying is.
But that's what you're saying in this context.
In Tennessee, the law, and the Court of Appeals lays this out, the law in Tennessee, Gray's lessee and that line of cases, state that there has to be something more than the mere recording of the lien. There has to be an action to dispossess the adverse possessor of property. And the action in this case is a commencement of an action to enforce the lien, which didn't happen in this
If
case
you were-
until 2016.
If you were the title attorney, and after February 7 of 2011, Mr. Eads was selling that property to somebody else, and you ran the title and you saw that judgment lien, what are you going to do?
I'm going to advise him that he needs to file an action to remove the cloud on the title, to quiet title.
So why is there a cloud?
Well, I'm sorry. Maybe I misunderstood the question. Are you saying after 2011?
Yes, after
well-
after it had ripened.
Well, there's a cloud because the judgment lien is still of record. And if he can prove his adverse possession rights, which he could and did in this
But
case.
according to what you're arguing, the judgment lien means nothing until you act on it, right?
No, it does, no, I'm not saying it doesn't mean, I'm not saying it doesn't mean nothing. Double.
Oh, yeah, okay, it doesn't mean anything.
Doesn't
Sorry.
mean anything. But
Sorry.
what I am saying is that it's there and they could enforce it up until February 7th, 2011. Thereafter, his rights ripened into full unassailable title. Keep in mind, Mr. Eads was not a party to this judgment lien. He didn't know anything about it. In fact, he never found out about it until right before he had to file suit to quiet title in 2016. How is he supposed to know about
But
it?
what about if it's a bona fide purchaser, or if there's let's not say bona fide. If there's a purchase, let's assume that, okay, judgment lien's recorded, and Mr. Eads sells the property to a third party after the judgment lien's recorded but not enforced. Are you saying that that's, as of that date, that the judgment lien still is gone as to that new party?
In the facts of this case, if Mr. Eads...
I'm not talking about the facts of this case. I'm just talking about generally.
Well, it depends. It depends on you're talking about before his rights ripen after 20 years, or you're talking about after. Because if he sells the property after his rights ripen, then no, the judgment lien's not a factor in it.
But you're
under your
putting the-
theory, If you prevail, how will any judgment creditor ever be able to rely on documents recorded in the Register of Deeds office. For example, you're saying something changes once that 20 years ripens in adverse possession. A creditor's not going to have any idea who's out here with adverse possession rights ripening. You've got to rely on documents in the Register of Deeds office.
And when you record your judgment lien, you take steps to enforce your judgment. Had they done
Not
this,
necessarily. I mean,
Well,
you
yeah,
record the lien, and usually you walk away until they want to sell it or borrow more money, and then they come to you and say, hey, we want to pay you off. That's generally how it works, right?
generally, but you've got, what, 10 years,
10
I
years.
think, to unless you renew the judgment, you've got 10 years to do it.
Right.
But according to precedential law in Tennessee, in the Court of Appeals sort of said it, summed it up with this statement. Hold on. Of course, I'm not going to be able to find it. Where a judgment creditor sits by and fails to enforce a judgment while the actual possession of an adverse claimant ripens into title, the latter has superior right.
But
But
doesn't
what
that,
about notice? I mean, how would they even know about it?
and it puts the adverse possessor in a better position. It's not that the person adversely possessing the property is getting the same right, the same property rights. I mean, that adverse possessor is actually getting a bigger bundle of property rights than, because it's no longer
purpose
encumbered,
would, yeah.
right?
Well, I guess in Mr. Eads' case, I mean, if you're talking about a squatter, sure. Mr. Eads was holding this under color of title. He had a deed, right? And so he's.
But you're relying wholly on adverse possession.
You don't even want to say he has a color
Right.
of title.
Well, but you're right. We are relying on adverse possession. But you either have adverse possession in this state or you don't. You know, I don't think, you know, the judgment creditor had the right to enforce their judgment. And had they done so in 2009 and 2010, number one, they would have learned from Mr. Whitaker that he, in fact, doesn't own the property anymore. He sold it to Mr. Eads. And they could have said, well,
They also would have known that had Mr. Eads recorded the deed.
Absolutely true. Absolutely
So
true.
where, from a public policy standpoint, do we
So-
place the burden?
So the burden here is you're not necessarily rewarding Mr. Eads for, you know, laying back and not recording his deeds. He owned and controlled and exercised dominion over this property for 20 years. And that's what he earned during that 20-year prescribed period, is the title ripening into full title for him, right?
Is there any question, so had you, let's say, you know, as you initially did, I think, relied on the later recorded deed for ownership of this property, that surely would be subject to the judgment lien.
Would, right?
Yeah, and that might
Except-
explain
right.
why you didn't
Well-
go that route, right?
Certainly, but again, his rights that arose after the 20-year period expired are independent of the deed. They arose because he possessed the property for 20 years. He controlled it, exercised dominion over it.
So he's in a
Right.
better position now than he, as an adverse possessor of the property, than
Well,
if he had recorded the
His
deed.
position is no different than it would be had he recorded the deed in December of 1990.
Because then he would have been record owner and true owner before the property was, or could have been encumbered.
Right. So he's not in the context of this case, he's not acquiring rights better than what he would have had he simply recorded the deed. It's just putting him in the place he would have been had he recorded the deed, but after 20 years of maintaining possession. And quite frankly, there's nothing in the record that indicates he was doing anything nefarious here by not recording the deed. Literally just forgot, right? I mean,
But there's no evidence the judgment creditor was doing anything nefarious either, correct?
That is true. That is true. They waited 7 years before, and they certainly have the right to do that. But the risk you run, just like the risk Mr. Eads ran by not recording the deed, is that you could have your rights interrupted. In the case of the judgment creditor here, interrupted by the ripening of title into unassailable title because of the running of the 20-year prescriptive period.
What other way, other than perhaps not renewing the judgment or whatever, what other way would that interest expire? So you're saying, in essence, that adverse possession, it expires under those circumstances, but so is there any other circumstances where that judgment lien would expire in that
Well-
similar situation?
So then you also have to ask the question in this case, what about the 7-year
Well, let's
statutory-
answer my question
Okay,
first.
all right. So is there any other situation in which the judgment lien would expire? So our argument is that the judgment lien is only expiring with respect to this property
Right.
that was subject to the adverse possession.
But is there
Assuming,
any other circumstance in the world, in the Tennessee world that you know of, that would be the same result other than adverse possession, according to your theory?
well, so perhaps a bona fide purchaser for value, of course, recording their interest before the judgment lien. Of course, that's a different story because that's a matter of priority, right? So,
It's going to expire after 10 years.
yeah, it's going to.
Well, that's what I said, but other than failing to
Other
review the
than,
judgment.
right. Other than some defect in the judgment, or maybe there wasn't, some defect in the judgment, I guess. Of course, that probably should be raised at the time the judgment is domesticated and recorded in Tennessee and not later. I possibly could think of some facts maybe but right off the top of my head, I really
You'll
can't.
think about them as you drive home.
Right, it'll come to me.
That's of course right.
It'll come to me, but right off the top of my head, I know. But I guess the other interesting question is, what is the effect of the 7-year statutory defensive possessory right that arises after 7 years? Assuming we didn't have a 20-year run here, would Mr. Eads still be able to use the 7-year possessory defensive statute to hold off the judgment lien? Yeah, I would submit yes, right? As long as he was in possession of the property.
But that's not what we have.
Well, that's not what we have, right? But the 7-year statutory possessory right is there, but we, of course, go further into that with the 20-year. And the 20-year is the creation of title in the adverse possessor. It's not just a possessory right, which is what the statutory, right, the 7 years, but it is an actual possessory title or title right? And this is supported, adverse possession goes back to the Roman Empire and probably before, right? So it's a significant foundational block of our property law. Not only in this country, but in England, Roman Empire, Napoleonic Code, et cetera, is a foundational block. And to upend it is somewhat chaotic, right? Because what does that mean?
But isn't it a little strong to say we're upending
Well-
entire adverse possession if we were to rule that the actual true owner of the property could not assert
Well-
adverse possession claim?
But in this case, I get that. If you're talking about the claim by Mr. Eads versus Mr. Whitaker, but when you're talking about people taking through Mr. Whitaker who have no knowledge of the installment deed, who have no knowledge of the history there, it is a different story. Adverse possession is a viable, tenable theory under those circumstances. It has to be, right? We're not talking about the grantor of the deed. We're talking about the people taking through him who don't have any knowledge of that. And he is adverse to them. Mr. Eads is adverse to them and should be able to maintain an adverse possession claim against them based on his 20 years of ownership, control, dominion over the property. So, all right, I think my time's running out. So unless y'all have any questions, I'm going to thank you for your time and attention. Appreciate it.
Just briefly, I'd like to posit the assertion that as it relates to adverse possession, it cannot be applied using different lenses to determine who the true owner of the property is. Because that concept of a true owner runs through other areas of property law. The true owner isn't depending on what vantage point you're looking at it from, the true owner is the legal title holder of the property, one that would prevail in a quiet title action. And that's why I think that from a public policy standpoint, from a consistency in Tennessee law standpoint, that the identity of the true owner can't have more than one answer. Because if it has more than one answer, then you don't have a definitive trigger point for any of these statutes to run, any of these time periods to run. Because if you're looking for different potential true owners and different people to be adverse to, then the knowledge, the notice, and all of those other things don't fit. And the other point I just wanted to make as it relates to I think to Milledgeville, to the idea of whether it was dicta or not, our position is, irregardless, it's a true statement of the law. And it's a correct statement of the law that we're asking this court to adopt.
Can you, I know you don't have much time remaining, but could you address the judgment lien point
Right.
your adversary is relying on?
Right.
Precedent, we've got these statutes that seem to address it too. Can you just
Right.
briefly
Right. I think
explain your position?
My position is twofold. Number one, that the analysis that spurred the conversation that was going with opposing counsel is all predicated upon the proposition that adverse possession is running during this time period. None of that applies if the adversity was never established and the time period was never triggered.
But let's assume it was.
Right. So if it was, then the public policy argument that I think supports our position is that you cannot have an exception for adverse possession read into a statute that doesn't contain it.
But isn't that exactly what adverse possession does, though? I mean, it's it's hard to imagine now in our online world, but adverse possession values people making actual hands-on productive use of land. If you've got somebody who's lived somewhere for 20 years, they're invested in it. They've improved the property, they've invested money, they've raised family, their children may have inherited it, all of that type of thing. And the doctrine of adverse possession aids the vigilant. If you have an interest in land, you have to do what your client finally did, which is show up, change the locks, all that, this is my property. But your client did not do that within the prescriptive period.
Well, that obviously under the theory that the prescriptive period was triggered. I think that the response to that is that there's no way you can look at this case without having to prioritize under public policy one position or the other that where neither has unclean hands or neither has some kind of equitable, nefarious element. And in this, if you read into the judgment lien statute an exception for adverse possession versus any other type of...
But adverse possession applies to, there's so many different kinds of iterations and
Sure.
Miscommunications, failure to do this, failure to do that when it comes to real property transactions. The whole point of adverse possession is if you have any kind of interest, if you inherit it, if you have a judgment lien, if you have any of those, you have to put hands on the property. Within a 20-year period is pretty generous. That's an entire generation that somebody has to actually assert hands-on their interest in the property.
Well, of course, in this scenario, the 20-year period and the period at which time the judgment lien attached are not equal, in the sense that obviously what you're referring to would be the rights of another owner that let that 20-year period go by. But I think we're dealing with a different animal as it relates to judgment liens that attach. And what I think from a public policy standpoint that I think the court needs to and should apply the public policy that, as mentioned before, so strongly favors the recording system, so that to create an exception of that system to allow for judgment liens to expire on pieces of property that somehow are adversely possessed, that when that statute doesn't contain that exception, I think would undermine the recording laws.
All right.
Thank you very much.
We'll take a short break.